Honorable Prime Minister Sri Narendra Modi ji, Honorable the Chief Justice Dr. Dhananjay Chandrachud, former Chief Justice of India and former judges of the Supreme Court and judges of the High Court, Honorable Minister for Law and Justice and Honorable Minister for State of Law and Justice, Sri Tushar Mehta, Solicitor General, Mr. Vikas Singh, President ACBA, and my other friends in the bar, ladies and gentlemen. It gives me immense pleasure to be part of this assembly on being together to celebrate our tryst of destiny with the Constitution 75 years ago, in solemn affirmation of our soulful commitment to it. When we gather in such solemnity year after year, we renew our affinity to all its aspects, and most fundamentally to the Constitution as our inseparable partner of life. Every utterance of the Constitution takes place, first through we the people of Bharat and a vibrant Bharat. We the people are the soldiers of a great nation who keep faith with the Constitution by visiting its processes and promises in many ways and take pride in being free and being together. Being together as one great family tree. The Bharatiya family is unique. Its roots are ancient. Its wealth of knowledge and culture are special. Its contributions to world civilizations are also special. All those enrichments of the past are being splendidly carried, shared, and exchanged by we the people of India, or Bharat, all under the common heritage of our country and under the umbrella of the Constitution. We therefore have a solemn pledge to embrace the legal fraternity and speaking constitutional language with we the people of Bharat, to journey with them, to share their pains and agonies, joys and tears, and to lend all our shoulders in promotion of their well-being and with equal regard for all lives. But the tasks are great and challenging. We are yet to eradicate some of the pernicious problems of caste and other social divides. The claims to equality is complex, and accommodation to be made call for coordination between law, society, and the courts, without, however, creating new divides. The new entrance in the field of human rights, particularly social media, has thrown open challenges of regulation. As we look at the number of rural, unemployed, urban adolescents in crimes and jails, it is disconcerting. The day when jails are empty of youth, the day when jails become really soul transformative, the day when our courts at the initial levels become comfort clinics, the day when every citizen in need of justice and finds it at the doorsteps, that day ought to be the day the legal fraternity must be looking for. As we look at the disappointed rush for some employment, at the other of somewhat educated youth, it is disturbing. Economically deprived sections of minorities or otherwise, another set of our people whose justice needs also call for special investments. I do not wish to be talking stuff of distress. All this I say is that I share deeply the pains and agonies of all those who are in urgent need of constitutional justice. The new roads of constitutional justice for them have to be laid. The Honorable Prime Minister always listens, and his heart and mind never rest without listening. The 200 and odd years of constitution making across the globe and their duration tell us great lessons. The fragile democracies in various parts of the world teach us lessons. The loss of ability of people in certain countries to staunchly abide by democracy and stand firm by rule of law are also lessons. It is only by keeping agile on our freedoms and freedoms of those in lack of it. It is only by swearing by an open society where all distinctions can melt that we would be keeping faith with the Constitution. The legal profession and the courts are twin gateways. I do not propose to dwell on themes only of concern to the Supreme Court bar. We are only a microcosm. However, some issues of concern may be flagged. It is important that government stops overloading the court with endless statutory appeals, alongside a seamless and huge flow of cases from high courts. The conversion of Supreme Court into a small causes court must stop, even though for one in trouble, any court is good enough. Whether we keep engaging our thoughts on a National Court of Appeals or not, we need to strengthen our high courts and also decongest them, which alone can stem the flow of work in the Supreme Court. Our property dispute laws must undergo review and must become settlement commissions away from adversarial motions. Our family courts must become family comfort institutions. For doing all this, we need a permanent law reforms commission with legal reforms wing, court reforms wing, coordination wing with the courts, and a dedicated research wing connected to law schools. The vast spread of people in varied deprivations who are justice hungry remain untouched. They lack public defenders' assistance. They lack neighborhood legal service provisions which must serve them 24 hours like hospitals. Every panchayat must have a legal service provision. In a digital age, making this happen cannot be a problem. The structure of free legal services, even in semi-urban and urban, are still far from matching the needs of demands. Most important and radically new ways of conceiving and organizing their basic needs through innovative institutional structures need to be explored. Socio-economic entitlements commissions, which can resolve social and economic needs and demands of deprived sections of the community, may be conceived to relieve courts from inadequately addressing them. Also, the need to come to courts to settle matters of salary or pay, or pensions or retirement benefits must cease. If there be a justice provision tax on the rich and the able, let it be conceived. I suppose the administration of justice comprehends all means of fulfilling these tasks. For long, governments have been talking about litigation policies. There is no reason why this policy cannot emerge. Every department must have a resolution wing with a competent and independent legal equipment to resolve fact-based issues. And every matter need not be a legal dispute matter. Only complex legal issues which cannot be otherwise settled must go for institutional resolution. I am confident that the government will lend its ears to an earnest Attorney General to draw a quick roadmap and all the above. If only we dedicate 1 year exclusively for each subject, we can progress with great dispatch. I think rule of law is a non-violent revolution. We do not need any violent revolutions, as all such revolutions are paths of totalitarianism. The more and more of rule of law means room for no violence. Bharat can lead the way by setting its own benchmarks. I would like to look for the day when the West may come for learning from us on justice standards. Colonialism of minds and people will then cease. By doing all this, our constitution will be beyond reputation and then refutation. Let us continue to march on the grand journey towards care of all and compassion without discrimination. I conclude my speech with a small piece of poetry addressed to my motherland. O nation of great mind and thoughts have passed so long and cradles many, that nurtured knowledge of shades many, many. O nation of people with ancient roots, with entanglements thin and bosoms lodge. O nation that know the dark divisions of faith and caste, like spider webs can trip and trap. O nation of many tongues and cultures, faiths and creeds, and blends and bonds, of fibers strong, why bleed our minds, why freeze our hearts, why fence our homes. With petty thorns, swords once drawn are poison strong, words once dropped are slipping weeds. Fold all your clashes, fold all your noises. Little device with constant chases can grow to seismic seasons quick. In composure, do all things flourish. In common pursuits of common weal, little skirmishes do dissolve. O nation of paths in beauty drawn, in common resolve of love for all, let our oars do swing and hail our life. Thank you for your attention.